Yes, Mr. Welling.
My Lord, we were just moving on to the stage 3 analysis of the additional spills, and that's only a point raised by respondents' notice. That's not a point that the judge relied on. In many ways, our answer to this is extremely short, which is if you've concluded at stage 2 that only the essential facts of 10 spills are pleaded, then the further 85 spills plainly don't arise out of the same facts because they're different spills which happened at different places at different times for different reasons. The oil went to different places. It will have harmed different people at different times to any other spill. And so there really isn't a separate stage 3 point in our submission on this aspect of the appeal. Now, obviously, in determining whether the new claims do arise out of the same or substantially the same facts, you are essentially just applying a statutory or the test in the rules. And there's a danger in my submission of trying to apply any gloss to that. One is just applying the words substantially the same. The authorities certainly tell you that substantially the same doesn't mean similar, which is plainly right. There are just 2 authorities I wanted to show you to the extent they give you any assistance. The first is Mullally, which is Authorities Bundle 4, tab 38. At page 1603. Facts of the case don't really matter. It was a Grenfell, post-Grenfell cladding type case. But it's really just to take you to the passage at paragraph 49. And I'm sorry for doing it in this way because it's a judge quoting another judge quoting another judge. But it's the easiest way of dealing with this point. And you'll see at paragraph 49, Lord Justice Coulson is referring to Ballinger and Mercer. And in Ballinger and Mercer, there is in turn a reference to Mr. Justice Coleman in BP and Aon. That's paragraph 34 of the internal, the quoted judgment. And that quote from BP and Aon, whether one factual basis is substantially the same as another, is obviously a value judgment. But the relevant criteria must clearly have regard to the main purpose for which the qualification to the power to give permission to amend is introduced. And then these words, that purpose is to avoid placing a defendant in the position where if the amendment is allowed, he will be obliged after expiration of the limitation period to investigate facts and obtain evidence of matters which are completely outside the ambit of and unrelated to those facts he could reasonably be assumed to have investigated for the purposes of defending the amended claim. And you'll have seen those words picked up in the quote that in turn features in my Lord Justice Mayall's judgment in Geominerals. And my learned friends actually use this test. They say in their skeleton, the facts that will need to be investigated are not wholly, completely outside and unrelated to those facts. And you'll see that after that quote, there's then a quote from Lord Justice Hobhouse in Lloyds Bank and Rogers, which puts the policy in rather different terms. The policy was that if the factual issues were in any event going to be litigated, the parties should be able to rely upon a cause of action which substantially arises from those facts. What I really want to get from this is how little those help. And Lord Justice Coulson says at paragraph 50, I'm not sure with respect how far those various observations really take us, although important to stress substantially the same is not synonymous with similar. Brickfield not cited. Further, in the most recent case which touches on this topic, Libyan investment in King, Lord Justice Nugent said that it was neither necessary nor helpful to seek to resolve the differences between some of these observations, since they were not and could not be a substitute for applying the wording of Section 35 of the Limitation Act 1980 or CPR Rule 17.42. So all I'm really trying to take from that is, although my learned friend uses the test of completely outside and unrelated to, that is a test that should not be applied. It is simply, as Lord Justice Nugent described it, at a high level, a statement of the principle, statement of policy at a high level of abstraction, and not a substitute for the statutory wording. And as I say, it obviously can't be right that something has to be completely outside and unrelated to facts if it's to fall outside the substantially the same facts exception. The substantially the same facts exception is rather narrower than that. The second authority, perhaps rather more helpful because it's a positive statement rather than a negative statement, is Society of Lloyds and Henderson. That's Authorities Bundle 6, tab 55, page 2297. Lord Justice Buxton said at paragraph 53, it was argued that a new claim, tab 55, page 2297, paragraph 53, before us it was argued that a new claim sufficiently arises out of the same facts if there's a sufficient nexus between the old and new claim in the sense that some or a substantial part of the facts relied on to promote the new claim were relied on to promote the old claim. That takes far too broad an approach to the rule, which it effectively rewrites. There's then a point about no new facts, and then at paragraph 54, it said the additional possibility that the new facts are substantially the same as those already relied on is limited, as Mr. Justice Coleman said in the Hour of Metals case, to something going no further than minor differences likely to be the subject of inquiry, but not involving any major investigation, and or differences merely collateral, proof of which is not essential to the cause of action. So one is looking that the substantially the same is a narrow gateway limited to minor differences which wouldn't require any major investigation.
But doesn't the passage you just cited from Mullally quoting Lord Justice Nugent apply in reverse to what you just said, that these are glosses on the statutory test, and the statutory test is substantially the same facts?
It is. The difference I would submit, is that this is interpreting what the test means. That the point in the case I previously showed you is that they were discussions of the policy of the statute. And so they're even further removed from actually attempting to understand what the test is. This is at least saying what the test is, an interpretation of the words of the test itself, and not a more abstract statement of the policy that the words try to serve. So in my submission, yes, they're a gloss, and yes, you need to be cautious with them, but they are far more helpful than the policy-style glosses that my learned friends seek to rely on. And ultimately...
I mean, this test gives no real weight to or substantially, doesn't it? Because it's simply saying they've got to be the same facts. If there are any new facts, then you don't qualify.
Well, that's the point made at the end of paragraph 53. But 54 says that there's a limited extension if there are minor differences, essentially. So the last sentence of paragraph 53 is new claim doesn't arise out of the facts. If any new facts need to be added, that's the same facts. And then paragraph 54 is dealing with the substantially the same, which is described as a limited extension to minor differences. And my lord, we do say substantially the same is a very narrow extension, because something's not, the use of that language, substantially the same, means in substance it is the same thing. And that is narrow.
It's not quite right. I mean, you're using a very, very elastic term of the English language, which is delightful for all to use. But there is a difference between substantially the same and in substance the same. It's very subtle, but it's real.
My lord, I have to accept that. And what I'm now doing is glossing, which is the very thing I say
exactly
one
you're telling us
shouldn't
not to
do.
Yeah.
But the use of the phrase substantially, one could have used similar. Substantially the same, it is still a modest extension to something that is identical, as opposed to mere similarity being enough. That's really the key point. That proposition, I think, is well established, that substantially the same does not mean similar.
while we've got the Henderson case open, what do you say about paragraph 58?
My Lord, this is touched on, and actually there are a number of cases that do touch on this, and whether or not it's a mixed question of fact or law, or whether it's an evaluative judgment. It's plainly not a discretion, and that is established by Lord Justice Sales in MasterCard. So it's not that sort of case where, providing it's within the reasonable range of answers, it's sufficient. Of course, this point doesn't arise on this appeal because the judge didn't make a finding that they were substantially the same facts. I can see it might arise in the context of illegal refining. But in my submission, these are ultimately evaluative questions where this court is as well placed to determine what the relevant facts are, what facts are going to be an issue, what facts are brought in by the amendments. And the court shouldn't feel any significant reticence in interfering if it reaches a different view. It's not the sort of discretionary cases where the court accords significant deference, if I can put it in that way, to the first instance judge.
Right.
And so, well, just to apply those here, as I say, the short point is the facts of a new spill do not arise out of the same facts as any other existing pleaded spill, nor are they substantially the same as any other existing pleaded spill. Every spill will have occurred for its own reason. It will involve a unique investigation, depending on when and where it took place. Even if there may be some common issues, that's the point that Henderson makes, that it's not enough that there is a sort of common core of facts that might support both the old and the new claims. When he's going to have to look at why did this spill occur, what could have been done to stop this spill occurring, would it have stopped this spill occurring, might have stopped another spill, and so on.
Mr. Welland, this is obviously an important point, but you have made it already.
Yes.
And on the timetable, the timetable says you're going to sit down in 15 minutes. You're not.
I'm not.
We ought to move on.
Yes. So illegal refining.
Yes.
That's all I have to say on additional spills. So as my Lord Justice Mayles observed this morning, there are two ways in which oil may be spilled from theft. One is in the course of the oil being stolen, oil is spilled. And that can either be the time of inserting the tap, or it can simply be, as in some of these cases, hacksaw was taken to the pipe, oil was drained away, but then the gash was left open and spilling oil after the theft had stopped. But that is oil spilling from the pipeline as a result of the theft having occurred. The second alternative is that oil is successfully extracted from the pipeline. It's then taken away, it seems predominantly by barges, taken somewhere else, illegally refined, and then the useless bits of it are dumped by the illegal refinery. And certainly the evidence suggests that that is a cause of a huge amount of pollution in the Niger Delta. In our submission, the original claim only covered the first of those two activities, and the amended claim seeks to hold us liable for the second of those two activities, the dumping by criminal enterprises of illegally refined oil. Let me just start by showing you what the judge decided. That's Core Bundle 1, tab 4, page 77. And it's really dealt with simply in paragraph 118. It is a very, considering the importance of this point, it is perhaps very tersely reasoned in my submission. You have a reference to the fact that the original pleadings referred to bunkering, that's paragraph 117, and paragraph 118, not an issue that by bunkering the parties meant theft. And that's, of course, using the sort of shipping sense of bunkering, i.e. taking oil onto a vessel, and this was taking it from the pipelines onto barges. The judge observes that Ms. Fatima, for the defendants, is right to say that the particulars of claim don't explicitly refer to illegal refining. But I consider that although the existing articulation of a duty to protect assets against TPI and breach of that duty does not in terms refer to illegal refining, the addition of a claim to losses arising from the use made by third parties of oil stolen from the pipeline is not a new cause of action. There's then reference to an argument Ms. Fatima made about kitchens and knives, and this was a point about if you store knives near children versus if you store knives near adults, what you have to do may be different, and the duties therefore may be different depending on what you have to protect.
Can I ask
against.
a very, very basic question?
Yes.
When you refer to illegal refining, it's not illegal simply because the crude is stolen. It is contrary to presumably some provisions of Nigerian law
There's
to refine in such circumstances.
There's a Nigerian statute that prohibits refining by anybody without
A license.
relevant authority. Yes. So it is illegal both in the sense that they are using stolen oil.
It adds another layer of illegal.
Yes, but it is
Thank you.
per se illegal.
Thank you.
Then the judge concludes that the duty to protect assets from TPI, where that includes the theft of oil, effectively won't be enlarged or changed by allowing the claimants to make a case that the failure to protect gave rise to foreseeable loss from the use made by third parties of the oil to which that was taken. So that's the stage 2 analysis, or purports to be the stage 2 analysis. In my submission, it doesn't really engage with the relevant questions, which are firstly, what facts were pleaded, and secondly, has that changed the duty, and has that changed the breach in such a way as to sufficient fact and degree to constitute a new cause of action. But that is the stage 2 analysis. Then the stage 3 analysis follows. Further, given the focus by Shell on pollution caused by illegal refining, I don't consider that these amendments would require Shell to investigate additional facts beyond those which they could reasonably have been expected to investigate. And then there's a point about difficulties on the merits. But that is then the stage 3 reasoning in that sentence. And again, we suggest that it didn't engage certainly in sufficient detail with actually what facts were likely to be investigated on the original claim and what facts would now need to be investigated. And indeed, the judge's decision doesn't seem to be a substantially the same facts decision. She simply says it wouldn't require Shell to investigate additional facts. So she seems to be saying no additional facts, but that may be a point of nuance. But that is the reasoning. Paragraph 119, the judge reaches a slightly or diametrically opposed conclusion on cleaning up spills resulting from illegal refining, which he says does enlarge the duty and does involve additional factual inquiry. I must say we struggle to understand why those two things resulted in such different conclusions, but there's no cross appeal against paragraph 119, so perhaps I can just say that that is an oddity. So in terms of the stage 2 analysis, the judge was certainly right to say there's no reference to illegal refining in the original particulars of claim, but we say she was wrong to find that there was no change or no enlargement of the duty. And second, we say that in any event, she failed to consider the question of breach and whether there was a sufficiently significant change to the facts of breach to result in this being a new cause of action in the cooperative group sense. Could I just go back to the pleadings in Core Bundle 1, tab 26, page 396. And just firstly to make the point that there is, it might seem to be no doubt that this was not a claim seeking to hold us liable for the consequences of illegal refining. Paragraph 1, you get reference to oil spills emanating from defendants' oil pipelines. Paragraph 23 on page 403, we've looked at before, spills from the pipelines and infrastructure. Obviously no reference to oil being taken elsewhere and illegally refined. And on page 407, paragraph 29, TPI was defined as including interference and unlawful bunkering, i.e. the process of taking the oil out of the pipeline and putting it onto a barge, the process of theft, but TPI was not defined before amendment as extending to the subsequent illegal refining. And you'll see that the amendment recognises, by adding the word subsequent illegal refining, that the illegal refining can't sensibly be described as part of the process of bunkering. And I should just say there is...
illegal refining that's complained of in the pleadings is not really the refining as such, but the dumping of the waste product after the illegal refining has been completed.
It is. It is. And I should just say that there is evidence, and I don't think I'll need to go to it, but I can if necessary, that there is evidence that not all stolen oil or bunkered oil is refined in Nigeria. There's evidence that some of it is simply taken on barges to tankers and exported internationally. So bunkering and illegal refining are not coextensive activities.
And deliberate dumping, one might think, is not really a spill.
Well, I mean, I've adopted the language of spill, but it's troubled me in that it's not really spill. It's a deliberate discharge of oil. But even now, my learned friends, perhaps cosmetically, choose to use the word spill to describe the process of deliberate release by the illegal refiners. But it clearly, if one had read this pleading originally, talking about spills emanating from the defendant's pipelines, no one in their right mind would have understood that to cover oil being taken elsewhere and then deliberately dumped. Then in terms of the amendments, and I will take this quickly because we touched on it in the course of my Lord Justice Stuart-Smith looking at the first defendant's duties. But if you go please to page 418, so here this is setting out why the first defendant owes a duty, and you'll see that in order to support the plea of duty there's an allegation of knowledge, so a fact, and it was said that we knew about the widespread pollution caused by spillages from our infrastructure, and it's now alleged that we knew of the damage caused by illegal refineries. So a new fact of knowledge. Similarly, over the page at 65, a new fact of knowledge that we knew of a very high risk to the environment from illegal refining. And at paragraph 66, that is relied upon to support the extended duty, which was a duty to avoid foreseeable damage from spills from our pipelines, and is now said to be a duty to avoid foreseeable damage caused by oil abstracted being subsequently spilled by an illegal refinery. Now, the first point to make, and it's a point I made this morning, if there wasn't a change to the duty, there wouldn't be a change to these paragraphs. There is a change to the duty, and that is why there are amendments to these paragraphs, both in terms of the factual basis for the duty and the duty itself. And that feeds into then the breaches at page 431, in that it's now specifically relied upon as supporting the breach, not only that we knew about the high risk of TPI, i.e. the theft itself and the likely damage that oil spills would cause, but that we knew about those things in the context of illegal refining. So it's saying we were negligent because we knew how much damage illegal refining of our oil would cause, and therefore we should have done more to stop it. So in our submission, the judge was simply wrong to say there was no enlargement to the duty. There was an enlargement to both duty and breach. Because what the claimants really want to do now is say not only that we should have avoided our pipelines spilling oil, but that we should have stopped people stealing oil from our pipelines, because once they do that, further things follow. And that's not an academic or inconsequential distinction. It has very real-world implications. First, we are now concerned with oil.
Hang on. Sorry to interrupt you. Have I misunderstood? Your submission is that they have in fact extended the duty not only to cover the illegal abstraction from your pipelines, but also everything to prevent them doing whatever else they do.
Well, not that far, but the original duty was to take reasonable steps to prevent foreseeable loss of damage due to spills.
Yes.
So what's said is you should do what's necessary to stop oil being spilled from your pipeline. They're now saying you should take the reasonable steps required to stop oil being stolen, irrespective of whether any oil spills from your own pipeline. It's perfectly possible.
Yes, I'm sorry.
If you don't mind, I'll merge that point into the ones I was going to make, which is in terms of explaining why this extension matters. First, we now have to look at oil coming from very different places. Before, all we were concerned about was spills from the pipelines. So all we're looking at is oil spilling from the pipeline. Where does it go? No doubt it spreads out in the water. One could follow that. But now we're looking at oil coming from illegal refineries. So we suddenly have to look at a whole different set of facts as to where did oil go to be illegally refined, where were the illegal refineries, where did the oil from the illegal refineries spread. Second, our evidence shows, and I appreciate this is not accepted as a matter of fact, but if one looks at the reports we made to the Nigerian regulator, many of those involve incidents where the pipeline has been breached, but no oil at all has been spilled in the sense of falling onto the ground near the pipeline. So in other words, the thieves did a very good job. They tapped into it very neatly. They stole their oil and off they went with it without causing a drop of damage to the nearby environment. Now, on the original pleaded duty, that is not a breach because we only have an obligation to prevent foreseeable damage from spills from the pipeline. Well, there's no spill from the pipeline, therefore we've done nothing wrong. Now, we are liable for that.
Hang on. Now you are liable? What for? Only if the theft of the oil then causes damage.
Only if it then causes damage, yes.
Okay, so not at the point of abstraction from the...
No, it's still, if one goes back to the duty at paragraph 66, page 419, before, if oil had been stolen neatly, if I can put it that way, no breach at all, because our only duty is to take reasonable steps to ensure that there is not foreseeable damage as a result of spills from the pipeline. No spill from the pipeline, no breach, no liability. But now, we are liable because we should have taken all reasonable steps to prevent foreseeable damage as a result of, including spills of oil abstracted from the Bille pipelines and subsequently spilled from an illegal refinery. So something that would not have been a breach before, because it didn't cause any damage within the scope of the duty, has now become a breach for which we are liable once there is a spill at the illegal refinery. And that simply has to be an extension of the duty. You've taken something that we weren't obliged to stop at all, and now you're saying that we had a duty to prevent it. And third, and linked to that, the question of what we had to do obviously varies. If you're asking, well, what are the reasonable steps to prevent foreseeable damage as a result of spills from the pipeline, one answer to that might be, and it's one of the things it's pleaded that we could have done, is that we could have had prompt leak detection and adequate containment strategies. Now, if we'd done that, it would have had absolutely no impact on the oil that had already been stolen. It would simply mean that we contained any oil that was spilled from the pipeline. and we cleaned it up. But that wouldn't have stopped the oil being stolen in the first place. It's essentially stopping the foreseeable damage as a result of the spills of oil. And so the question of what reasonable steps can you take has to depend on, well, what are you trying to prevent? Are you trying to prevent damage from spills from the pipelines? That may involve you doing one thing. Or are you trying to prevent oil being abstracted from the pipelines, which may involve you doing a whole host of different things? Equally, if very little oil spills from the pipeline, but vast amounts is stolen, which if the thieves are good at their jobs is the way around you'd expect it to be, you may well say that affects what the reasonable steps are. Your reasonable steps are only to stop damage from spills, and very little oil is spilled, you might not have to do very much. But if your duty is to take reasonable steps to prevent oil being abstracted and illegally refined and discharged, and that happens on a grand scale, the reasonable steps, because of the harm that you're trying to protect against, may be very much larger.
I've never done a case involving abstraction, so I don't know how leak detection works. But in related fields, I would expect the leak detection to be activated if the thieves cleverly cut in and started just nicking the oil.
Well, my lord, there's a certain amount of evidence for that, and whether it was possible or not, which I don't really want to get into. But I suppose all I'm doing is saying, hypothetically, one can imagine that if all you've got to do is stop damage from the spill, actually having a process where you get there quickly, put bunds up and stop it spreading may be enough to discharge that duty. But it's not going to be enough to discharge a duty to stop the abstraction. And so I'm not saying what the answer would be on the fact. I'm simply saying the duty is obviously different.
Well, that much I can understand, I think.
Well, my lord, I feared that I was overcomplicating, which I probably have. But I hope the examples illustrate why this isn't just, I'm not trying to imagine ways this could be different. It, in very real sense, is a different duty. And so, my lord, we say that the judge was simply wrong to say it didn't extend the duty. It extended the duty, and then in light of the extended duty, it relied on an enlarged breach. And that is equally true of the claims against D2. But I'm not going to go through those, in that no one has suggested the position differs as between D1 and D2. And my lord, just stepping back, I appreciate again the risks of doing this at a level of abstraction, but this does pass the common sense test. A claim that you're liable for oil coming out of the pipelines, spilling out of the pipelines onto the ground, is a very different beast to a claim that you should have prevented your oil being stolen and bad things being done to it, but with it, by other people. They are just different claims. And the idea that adding in that second form of liability it is not a new claim. It is, in my submission, both as a matter of analysis and as a matter of impression, unsustainable. That then takes me to the stage 3 analysis. And as I say, the judge seems to have said that there were no additional facts at all. We submit that the judge failed to analyse really with any detail what facts would have to have been investigated on our defence and what facts would need to be investigated on the new claim. And there are really two areas where we say that there clearly are significant or more than minor new facts that fall really into one being more significant than the other. The first is that, as you saw, new facts were pleaded about our knowledge of illegal refining, that we knew the scale on which it happened, we knew the damage which illegal refining caused. Those are new facts. What we knew about the risks of, what we knew about the fact that people were stealing oil and the risks of spills from the act of stealing is different from what we knew about what then happened with the oil, how much of our oil gets illegally refined, how much damage that causes.
It may not have been pleaded, but it's a bit hard to think you didn't know about it.
Well, my lord, that in my submission may or may not be right, but it isn't the test. In that the question is it a significant new fact? Not, is it going to be one that it's easy for them to prove? And in my submission, it undoubtedly is it is a fact, which is not substantially the same as the fact they've pleaded. And just on the premise of the question, I certainly wouldn't accept that we knew how much of our oil was being illegally refined. And that is something that would have to be investigated. Certainly, I'm not suggesting we didn't know that our oil was being illegally refined. Well aware of that. But in terms of the scale of it, which is what they rely on, that is something that would have to be investigated. The second, and I accept, much more significant factual investigation is that it would be necessary to examine on the claim where the illegal refineries were getting their oil, because the claimants only seek to hold us liable for releases of oil that has been stolen from SPDC. Yeah. So to the extent that the illegal refineries were getting their oil from elsewhere, and we know on the evidence that there were pipelines running nearby, we would not be liable for that. And the claimant's case necessarily requires an investigation, therefore, of where were the illegal refineries getting their oil from and how much of that was SPDC oil. And it's not simply a global analysis, that is an illegal refinery by illegal refinery analysis. Because let's imagine you have an illegal refinery on the west of Bille, an illegal refinery on the east of Bille. The illegal refinery on the west of Bille steals oil from a different operator's pipeline. The illegal refinery on the east of Bille steals oil from SPDC's pipeline. And those two refineries both discharge oil. Different people on the east and west are likely going to have been injured by different releases from those illegal refineries. And even on the claimant's theory, SPDC, or the defendants, can only be liable for the releases from the illegal refinery that is using SPDC origin oil. And so you can't simply say, oh, well, there's illegal refining going on and it must use quite a lot of SPDC oil. For the claimant's case, you have to look at each illegal refinery. Where was it getting its oil over the relevant period? Was it getting it from SPDC? Was it getting it from elsewhere? As I say, we can only be liable, even on the claimant's theory, for one of those. I did say it. And my lord, that's, one can imagine that the exercise of investigating the criminal underworld and where they steal their oil from is going to be a massive exercise. So when my learned friends say, well, look, you put in issue illegal refining, the problem with that is, yes, we did put in issue illegal refining. We said there is lots of oil in the Niger Delta that comes from illegal refining. But we were completely agnostic about where that oil came from. Didn't matter if it was Shell oil, didn't matter if it was other people's oil, because we weren't being held liable on either of those scenarios. But to turn this into a claim, the claimants have to say, these refineries were using SPDC oil. And that is a new fact. It is a new fact that was not in issue in any way on the defence. It was completely irrelevant to the defence. We've never alleged that it was our oil that was being illegally refined. And that is a new fact that goes far beyond something that can be described as a minor difference. And my lords, the point made in Mullally, which is Authorities Bundle 4, tab 38, page 1606.
606.
1606.
Thank you.
And it starts at paragraph 71. And what was being dealt with was a submission that when it came to facts raised by the defence, there couldn't be a single new fact if you were going to turn it back on the defendant. You see that recorded in paragraph 71. He said that the principle in Good and Martin only applied if the new claim relied on no new facts or matters at all. That argument is rejected, and you see at the bottom of paragraph 74, about 6 lines up, what I think Lord Justice Brooke had in mind was a situation where the same basic facts as are pleaded in the defence are then turned back on the defendant with some modest degree of leeway permitted for expansion or elaboration. And then over the page at 78, paragraph 78, it said it can't be right that on a claim you look at the same or substantially the same facts, but on the defence you only look at the same facts. And then over the page 81, the conclusion, therefore, is that the proposed amendment has to be considered by reference to the same or substantially the same facts that are already in issue, including those set out in the defence. So when the claim is turned back on the defendant, my learned friends can rely on substantially the same facts as we rely on, but they can't expand it beyond that. And that means that given they have to rely on the fact that the illegal refineries were using SPDC oil, that is more than a minor difference. It's one that requires a massive investigation, and that therefore cannot be said to fall within the substantially the same facts exception. So although I accept, as my Lord Justice Mayle said this morning, illegal refining, in a sense, was plainly an issue, we squarely put it an issue in the defence, actually when one distills that down and says, well, what facts were you relying on in the defence? Simply the fact of illegal refining. They need to add something that goes far, far beyond the mere existence of illegal refining to turn this into a positive claim against us. Now, my learned friend's answer to that, and I think it is just worth showing you this, is in Core Bundle 1, tab 8, page 141. And they're dealing with this point in paragraph 46 at the bottom of the page. The defendants assert the illegal refining amendments would give rise to a need for additional investigation of, one, whether any oil used in an illegal refinery had come from SPDC's infrastructure, and also they deal with the duty-related points which I talked about. However, a need for some further investigation is not inconsistent. I agree with that so far as it goes, but a very limited further investigation. B, here any additional factual investigation would not be completely outside the ambit of and unrelated to the facts which we could be assumed to have investigated. Well, wrong test. Specifically, and then they deal with the breach point, then in 2, any additional factual investigations as to whether oil used in an illegal refinery had come from SPDC's infrastructure would be closely related to investigations which would need to be done in any event regarding TPI with the SPDC's infrastructure. But we disagree with that. It's got nothing to do with the source of the oil for illegal refining. Any such additional investigations are likely to be minimal, given that, 1, absent clear evidence to the contrary, it's a natural inference that oil processed in an illegal refinery will have been taken from nearby infrastructure. 2, there was no third-party infrastructure in Bille. My learned friends have drafted that very carefully, because as we saw, there is plenty of third-party infrastructure just outside the boundaries of Bille, including whole fields that are producing oil. And then there's a point about Agale, that the facilities there use, pipelines there use refined products. But the problem with this is it's simply asserting what they want to prove, which is they're going to be able to show really easily that the illegal refineries must have been using SPDC oil. Well, we don't accept that. We're entitled to investigate it. And that's why CPR Rule 17.4 bites. In any event, it's far from obvious that that's right. We're in a river-based community where the oil is stolen on barges. There's no reason to think it can't be moved over reasonable distances. We know there is evidence that it's moved to sea to be loaded onto tankers, so it certainly can be moved. We know there is third-party infrastructure very nearby, including a whole field operated by another person. And so it simply can't be said, oh, well, it's so obvious that we're right on this point, that it was all SPDC oil, that there's nothing for you to investigate at all. It's really easy.
As matters stand, is the question whether you are legally responsible under Nigerian law for dumping from illegal refineries one of the questions to be determined at the preliminary issues trial?
Yes.
So if your submissions on this appeal succeed, that all falls away, does it?
Yes, I suppose, unless... Yes, I think it...
And conversely, if the preliminary issues trial goes against you, then the question whether it's pleaded becomes critical, does it?
Yes. Yes. And conversely, if we win on the preliminary issue, it becomes a moot point anyway.
Yes.
So, my lords, those are points. We say, my learned friends seem to rightly accept that it is a new fact that would need to be investigated. And the answer to say, well, it's going to be really simple, is not a good one. It's simply not. The reality, when one thinks about this, is investigating the criminal underworld is going to be a major investigation. So we invite you to conclude the judge was wrong at both stage 2 and stage 3, and to allow the appeal in relation to illegal refining. In the last 12 minutes, I'm going to quickly deal with MasterCard.
Can I take up 20 seconds, which you don't need to answer now? I've somewhere in my reading before today, I've seen talk about barges and so on and so forth.
Yes.
Can you give us a reference to that at some stage?
I can. It's Boyne 3, Mr. Boyne's third witness statement, paragraph 60. Oh, no.
Boyne 3,
Boyne 3, paragraph 48, which is supplemental bundle 2, tab 24, page 480.
Thank you.
And if my lord's very interested, there's an article actually that someone's put in the bundle, which actually talks about it in some detail, which is in supplemental bundle 3, tab 61, page 894 onwards, which talks about exporting on barges.
Well, that's a treat in store, I certainly haven't.
I wouldn't want to deprive my lord of it.
No, please don't.
The MasterCard approach.
Yes.
So my own friends say, if they're wrong on everything else, you should nevertheless allow the appeal, allow the amendments on the basis of an order that they will only relate back to, they say, the date that the proposed amendments were served. Two answers in response. We say you don't have power to do that. And secondly, even if you did, you could only relate them back to the date of judgment. That's 22nd of November, 2023. Now, in terms of the PowerPoint, the starting point obviously is Rule 17.4, which says if a limitation period has expired, then you can allow those amendments only if a condition is satisfied. And if you've reached this point, you will have decided that those conditions are not satisfied, and therefore, in my submission, the only if conditionality is not satisfied. And that, of course, derives from Section 35(3) of the Limitation Act, which expressly provides that the High Court cannot allow an amendment where the limitation period has expired, save in circumstances permitted by the rules. And so that is an express limitation on the court's powers. And indeed, Lord Justice Henderson, in the Blue Tropic case, talks about it as a jurisdictional point. The reference for that, I don't need to tell it, is Authorities Bundle 1, tab 7, page 174, at paragraph 2. Equally, in the context of the Limitation Act at least, Section 35(1) provides by statute when an amendment is deemed to have been commenced. That is not an exercise that requires a court order or is subject to the court's discretion. It is a statutory rule as to when an amendment takes effect. Now, the effect of that was considered in the Welsh Development Agency case. That's Authorities Bundle 7, tab 67, starting at page 275. 2755.
2750.
Sorry, 2756. I apologize, 2756. And between D and E, Lord Justice Glidewell, I think it is dealing, and I'll come to the context of this, but he says the following. Section 35.3 could not then, as it were, reinstate this defence. Indeed, in our view, Section 35.3 is not a provision which creates a defence, and then this, but a mandatory direction to a court dealing either with an application to amend a new claim or an application to strike out a claim added without leave by amendment or a contribution notice. So the point I take from that is that Section 35.3, which is essentially the bit of the Act that says you can't allow an amendment where the limitation period has expired, except where permitted by the rules, it's not an objective to be achieved. It's not something the court, provided the court achieves the purpose of that section, all is well. It is a mandatory direction to the court as to how to deal with the amendment. Now, the context of that, if my lords look up at paragraph C, was that they are dealing with the decision of Kennett and Brown, which they say is wrongly decided. And you see it at E. For those reasons, we conclude Kennett and Brown was wrongly decided. Kennett and Brown being a decision of a two-man court of appeal, so they felt able to overrule that decision. Now, if my lords just turn back to page 2755, you'll see from D to H there is a quote from Kennett and Brown. Could I just ask your lordships to read what's said there?
Where? G to H?
D to H. So it's
D to H.
D to H. So the entire quote from Kennett and Brown. So, my lords, what had happened in Kennett and Brown was that Lord Donaldson had effectively made an order on what that we would now understand as being the MasterCard basis, that you could run the Section 35.3 defence at trial, so you allow the amendment to go in, but the defendant, and you see this immediately following the quote, Lord Donaldson MR, Master of the Rolls, then said that the new claim was not dependent on a prior application of Section 33, that's to disapply the limitation period in personal injury, but that the second defendant could plead Section 35.3 in his defence. So Lord Donaldson was envisaging, well, let it in, even though you've got an arguable limitation defence that might engage 35.3, and we'll deal with it all at trial. You can say at trial, it shouldn't have been allowed under 35.3, and the court can then refuse to give judgment on it. So although not framed as a MasterCard order, it is identical to what the MasterCard order is doing. The court is saying, we'll just deal with this point at trial and you won't be prejudiced by it. Court of Appeal in ratio in Welsh Development Agency say that that is wrongly decided. Now, if MasterCard were an available approach, one would have expected the Court of Appeal to say, well, of course, Lord Donaldson could reach that, could grant an order on that basis simply by ordering that's the basis on which the amendments are to be allowed in. But they don't. The Court of Appeal says wrongly decided and then goes on to establish at page 2758. And it's the passage between G and H. Having dealt with Grundy, which is one of those cases where the limitation period either expired before the original claim form or long after the amendment, so the section 35 point made no difference. Around H, Lord Justice Guidall says, in such a case, leave to amend by adding a claim should not be given unless the plaintiff can show that the defendant does not have a reasonably arguable case on limitation, which would be prejudiced by the new claim, or can bring himself within what is now CPR rule at 17.4. And that is the well-established position that one simply can't allow the amendment. And my Lord, I think Lord Justice Stuart-Smith referred to the Chandra case, I think it was my Lord, where, and I'll make sure that is handed, actually let me hand that up to you just so you've got it. If I may. Don't mind me doing it, I'll make myself useful. Thank you very much. And of course, I should say immediately, I don't suggest that this point was argued in Chandra, but if you go, please, to paragraph 66.
Where should we put this?
Possibly straight after Welsh Development Agency would be as good a place as any. It relates to the same point, not in alphabetical order, but if you call that 67A. And again, I stress that no one was suggesting MasterCard in this case, but paragraph 66, Lord Justice Jackson says that if the claimant seeks to raise a new claim by amendment and the defendant objects that it's barred by limitation, there are two options. First, deal with it as a conventional amendment application. Alternatively, you can order that it be tried as a preliminary issue. And note there is no third option of, well, just make an order saying it doesn't relate back. And 67 and 68 deal with the first option, i.e., is there a reasonably, then all the court looks at is there a reasonably arguable limitation defence? And then paragraph 69 makes this the point that my Lord referred to this morning, leads on to a separate and important point. If the claimant applies for permission to amend and the amendment arguably adds a new claim, then the claimant should take steps to protect itself. The obvious step is to issue separate proceedings, and we say that is precisely what the claimant ought to have done here, and the fact that it will now find itself with a claim only starting in 2024 is a consequence of its own decision not to take the conventional steps to protect itself. But as I say, we say Welsh Development Agency binding ratio to the effect that you cannot effectively allow amendments on this basis. You must apply the wording of section 35 and rule 17.4. The last authority I need to show you before I sit down is the Duke of Sussex case, which is Authorities Bundle 3, tab 16, page 752.
How many?
752.
Thank you.
As I say, there's been a few cases where the ability of the court to make a MasterCard order has been debated at first instance. This is the latest decision I could find where there was a decision on it. I think there's a subsequent decision of Mr. Justice Bryan where he leaves the point open. But you will see if you go to paragraph 79, actually 78 on page 751. In all the cases except Libyan, the parties were agreed how the valid part of the claim could be pleaded by way of amendment. In Libyan, on the other hand, the parties were persuaded to agree, in effect, to defer to trial the determination of the application under Rule 17.4. Central line, the question of whether the court had power to impose a Libyan-style solution was considered in advanced control systems. That's the decision of Mr. Terhar, sitting as a Deputy High Court judge, where it was common ground that some of the amendments might be statute barred, but others were valid. No concession that any claim was statute barred, so similar to here. Limitation issue about all the claims sought to be pleaded. The claimant proposed to sidestep the immediate issue, whether the permission to amend could be granted by having the order state the amendments permitted by paragraph 1 are to take effect from 1st of March 2021. And that's effectively what my learned friends are asking you to do. Paragraph 80 summarises the consequences, same as they are here, effectively defers to trial which claims are statute barred. Paragraph 81, Mr. Terhar held that the parties could, if the parties could agree to such a course, as he considered the previous decisions, like MasterCard, confirmed, the court must be able to impose it, since the parties couldn't agree to do something that Section 35 Limitation Act didn't allow. He gave permission, and Mr. Justice Fancourt says that went further than MasterCard or Deutsche Bahn had in fact done. And I should just pause there to say, we obviously disagree with Mr. Terhar's reasoning to this extent. The reality is that in MasterCard and Deutsche Bahn, the court simply didn't have to consider the question of whether they had power, because the parties were content for it to be agreed, and therefore there was no need to consider whether the court had power to do so. And then so to seek to extrapolate from a non-decision on that point, the fact that there must be a power to do it, we suggest is a step too far. Paragraph 82 then discusses a case called Media Trust, where ultimately the point didn't arise for decision. Over the page at 85, get to the critical point, does the court have power to make that order if one of the parties does not agree to it? At 86, and I emphasise this, literally, Section 35 and Rule 17.4 do not permit such an approach. And I say that's plainly right. Rule 17.4 says the court can grant an amendment only if certain conditions are satisfied. He says literally doesn't have power, but he says at paragraph 87, where an ACS order is made, the purpose underlying Section 35 can be achieved, in that the defendant's not deprived of its ability to rely on limitation as though a new claim form had been issued, but the determination is deferred, and then discusses that. And then in paragraph 88 says, it therefore seems to me that the court ought to have power to permit an amendment in ACS form, where but only where that is just and convenient. And essentially our short answer to that is, it may well be that the court ought to have the power to do it, but it doesn't, because Rule 17.4 says you can only grant the amendment if the conditions are satisfied. It doesn't say you can grant it on terms. If you don't have the power to permit the amendment, you don't have the power to permit it on terms. And whether the court ought to have it is a question for Parliament and the Rules Committee. The answer to this appeal is 86. The rules don't permit it. And of course, it doesn't seem that Mr. Justice Fancourt was asked to consider the decision in Welsh Development. I think I'm right in saying wasn't asked to consider the decision in Welsh Development Agency. And the point I've made, that the court expressly overruled a case in which effectively the MasterCard solution had been allowed to prevail.
It looks as if in the end the point didn't need to be decided in the Duke of Sussex case, because the defendant didn't press the point that the court had no power.
Quite. In the end, even here, it was not, although his lordship seems to have decided it, the point ultimately doesn't seem to have been pushed by the opposing party. But, my lords, we submit, therefore, that the proper analysis is rules don't allow it. You have an expressly limited jurisdiction. As soon as you get to the point where there is a reasonably arguable limitation defence, your powers to grant an amendment fall away unless the conditions of Rule 17.4 are satisfied. The last point that I need to make is the date.
Well, just before you leave the PowerPoint,
yes,
you won't have time to look at it yet, but I'd invite you to have a look at the case I mentioned this morning, in case that does have a bearing on this. An undertaking was given,
yes,
and that was satisfactory to the Court of Appeal, even though I think there was no agreement that the undertaking would be enough.
Yes, so far as I can see, and I will look at it overnight again, the Court of Appeal dismissed the appeal on the basis that they would have allowed the appeal.
Don't take time now if you're going to look at it again.
Yeah. The date point is simply this. If you are persuaded that the MasterCard approach is available, then the relevant date must be the date on which the amendments were granted, and not, as my learned friend would prefer, the date on which the amendments were served effectively in draft or the application was made, which has quite a significant impact in this case, because the drafts were first served back in 2022. And the simple reason for that goes back to Welsh Development Agency. If you have that one last time, Authorities Bundle 7, tab 67, page 2753. And you see at the bottom of page 2753, Mr. Keating, the agency, was challenging the judge's conclusion that the relevant date to be considered was the date on which the amendments were granted, rather than the date on which the application for leave was made. And over the page on 2754, at letter C, the Court of Appeal say the judge's decision on this issue was entirely correct. The wording of section 35.3 can't be made, neither the High Court nor the County Court shall allow a claim to be made. That is so clear as to admit of only one interpretation. That is that the relevant date is the date at which the amendment is actually made, which by definition must be no earlier than the date when leave is granted. That therefore means that if you are entitled to grant relief on the MasterCard basis, it can only possibly relate back to the date permission is granted. Otherwise, you'd be doing the very thing forbidden by section 35.3, which is potentially reviving a claim which had become statute barred before the amendment was in fact granted.
If that is the rule, as you say, wouldn't it just encourage the courts to adopt a practice where claimant wishing to amend goes along without notice, obtains an order allowing the amendment with liberty to the defendant to set aside, apply to set aside, and then the whole thing is decided at leisure months later?
It might, or certainly might, encourage applications for expedited hearings of applications where limitation is potentially coming up. And that was a point argued in the Welsh Development Agency case, where you see at the top of page 2754, letter B, Mr. Keating argues that the right to amend would depend on arbitrary factors such as how long the court takes to decide the application. But nonetheless, the Court of Appeal say, well, that's what the statute says. And I'm not sure I can improve on that as an answer. Of course, the reality is the answer given by Lord Justice Jackson, which is any sensibly advised claimant who has a potential amendment which might be shortly becoming time barred will issue a protective claim form and then say to the claimant, look, somehow or other, I've got this in before the limitation period, either by consolidation or by amendment. So why are we having an argument about it?
Right.
So, my Lord, with apologies both to your lordships, to the transcriber for the speed at which I've been speaking, and to my learned friend that she's on her feet slightly later than I promised. Unless I can assist further, those are my submissions.
Thank you very much, Mr.
Thank you. And of course, I recognise I'll have to cut my reply accordingly.
You will. Yes, Ms. Day.
Good afternoon. You will have noticed that I'm not Mr. Hermer. For obvious reasons, he isn't here.
As he once was.
Yeah. I understand he's still alive and kicking, and I know this was a case that he cared greatly about. and I know he'll be very sorry that he can't be here today. And I wanted just to start by just standing back for a moment and by making some preliminary comments that I say are relevant both to the amendment appeal and obviously to the global claims appeal that you will hear tomorrow. There is no dispute between anybody that what occurred was a massive environmental catastrophe. And you will have seen that no one disputes that the claimants have suffered, they carry on suffering, and about 10% of the Bille claimants have died since these proceedings were issued. Now, obviously what has happened is that some 7 years were spent establishing jurisdiction, and unfortunately we've spent the last 3 years being treated to a battle such as you will be treated to over the next 4 days. And it was a sobering thought to me on reading the bundle that there's a draft order that was prepared in September 2021. It's at tab 34 of the bundle, of Supplementary Bundle 2. And that had proposed directions which would have seen these proceedings almost tried by this point in full through the use of lead claims and with disclosure, standard disclosure having taken place in April and June 2022. Instead, we have been treated to being prevented from the progression of the claim at every point. And the reason I mention this now in response to the amendment appeal is I hope to be able to show you relatively shortly why the amendment appeal is flawed on both grounds. It is, I'm afraid, a different stick to beat us with, but it's one that is being yielded to seek to prevent disclosure taking place, experts looking at this material, and once that happens, the roadmap to resolution, whatever that resolution may be, will take place speedily, even according to the defendants. I wanted just to take you, before we look at the amendments, to Mr. Boyne's 10th witness statement, because I say this calls into question why 4 days of Court of Appeal time are being wasted dealing with these issues. So it's tab 33 of the supplemental bundle. And this is a witness statement that was submitted in relation to the order that was sought for what's known as the 3 C's trial. But within it, it says some interesting things that are very illuminating to the correct way in which this litigation can be put back on track by this court. First of all, if you look at page 656, paragraph 46.
Just a housekeeping point.
Yes.
This is part of a witness statement, is it?
Sorry, yes. So if you turn to 649, you'll see this is the 10th witness statement of Christopher Boyne. Who
paragraphs 26 to 62.
Yes, it is, yes.
Good.
And the bit that's been extracted is what was said in relation to the order that was sought for what's been known as the 3 C's trial, which is this wide-ranging investigation into pollution between 2011 and 2013. You will see that what is said there at 46, and he's talking here about the parties' experts. In fact, if we turn back to 655, he's talking about the causes of the oil contamination in different areas. Just while we're on 45, you will see that one of the things he accepts that the expert will be considering is illegal refining. And I will show you that under the GLO order 2 years ago, illegal refining is already part of this case. You haven't been taken to that yet. But why we're having an argument about the amendments really beggars belief. If you turn over to 656, you will see at paragraph 46, he says this: the parties' experts will be asked to carry out this exercise. This is the exercise of determining causation using multiple sources of contemporaneous evidence available to them. The need to consider multiple sources of evidence is of particular importance to the issues in this litigation because the parties' experts are unlikely to be able to draw definitive conclusions from any one source. This is due partly to limitations of available evidence and partly to the passage of time, which means it's not possible to reconstruct the events on the ground as they happened over a decade ago. Now, that is an acceptance, a rightful acceptance, that evidence is needed from many sources, but that once the experts have that, they will then be able to draw appropriate conclusions. And if you turn back to 655, in the middle of paragraph 44, you see that the defendants there envisage that there are likely to be significant areas of agreement between the parties' experts as to where oil contamination occurred in 2011 to 2013. So there is hope. There is light at the end of the tunnel. It's simply that we need the assistance of this court to get there, because we are stuck in this catch-22 where whatever we plead isn't enough. There's continual attempts to prevent standard disclosure taking place. You have heard today that it's agreed there's been no disclosure, for example, on liability issues. So when we come to look at some of the issues we're talking about on the amendments, we have had no disclosure. It's agreed in relation to that. And where the disclosure we've had, we'll look at this tomorrow, has been very, very limited. And it is not sufficient for the experts to do their job. You have sworn evidence before you. If we could just get to this point, then the key to this litigation is unlocked and it will be resolved swiftly and effectively. Now, if I turn back to the amendments, because this is the latest stick which is being used against us, and I want to deal with them in reverse order, and I want to set out our headline response to them, and then I will go through them in a little bit more detail. But if I can take, first of all, the illegal refining. I'm going to show you just 3 documents, and I will go into more detail later, but there are 3 documents which show that this appeal is, with respect, a bad one. Because illegal refining is already an issue in this case. And it's in issue not just in terms of causation, but in terms of the defendant's own actions. So can I start with the defendant's defence, which is at tab 34 of Core Bundle 2.
Can we be clear on terminology? Seems to me that the ordinary meaning of the term illegal refining would mean things happening away from the defendant's pipeline, as opposed to third-party interference with the pipeline itself. Is that the sense in which you're using illegal refining?
Yeah. Luckily, we have, again, Mr. Boyne, in his third witness statement, who has given you a description, at least of what the defendants mean by it, which we say is very helpful. So perhaps, before I go to the defence, we'll just look at that, because I hope it will assist the court. It's in Supplementary Bundle 24, page 480. And this, just to orientate you, you will see at page 476. Again, it's an extract because otherwise you would have too many pages. I think you've already had enough authorities to last you a lifetime. Yes, and this witness
We tend
statement.
to have enough authorities to last us a lifetime in every case.
Yeah, I'm sure that's true. So this is dated the 9th of November 2022. So this predates any application for amendments. And if you turn to page 480,
Yes.
because the picture is actually more nuanced than it's been presented to you, but it's set out here in black and white by the defendant's solicitor. Oil bunkering is crude oil theft. So where criminal third parties steal crude oil, the stolen crude oil is then either sold internationally or refined illegally in the local area. So they're not distinct categories. So bunkering can also, my lords, lead to illegal refining. So the way in which it was being presented earlier isn't actually quite right. And then 482, there's reference to crude oil theft and an explanation as to how that can lead to oil spills. And then there's an assertion that a significant proportion were caused by crude oil thieves siphoning oil. And then they talk about they fit a clamp or other illegal fitting in order to siphon oil off for processing in illegal refineries. And then if we go forward to page 484, illegal refining involves burning oil at high temperatures in makeshift tanks, sometimes referred to as bush refineries or KPO fire, found in the swamps. The crude oil is distilled through this process into products. And then there's discussion in 57 that it's said to be a very significant cause of oil pollution. So I hope that assists in explaining the difference between them. Although they're interrelated, there obviously isn't a bright line between the two because bunkering can take place for the purposes of illegal refining.
Earlier on, there's a reference to Nigeria losing 470,000 barrels per day to crude oil theft. Against that number, the numbers that you've pleaded are absolutely minuscule, aren't they?
Yes. But
Just trying to get a handle on what the reality behind this action is. We're talking. So I don't know how much Bille would contribute to 470,000, but one of the things that struck me going through Annex 3 or 1, depending which action it's in, is that the number of barrels lost in virtually every case are minuscule, but to support a claim which is widespread crude oil pollution. Am I just misunderstanding something completely?
well, I mean, the point is that until we have disclosure, we're never going to be able to set out chapter and verse on exactly what happened. And the numbers that we've had to plead to date are obviously based on the JIVs. And you will have seen that part of our case is those are inaccurate. And it's not just us saying that, that's been proven through a number of sources.
But Amnesty say that, don't they?
So two things to say on that, or three actually. One, at present, we're having to rely on incomplete and inaccurate information. Once you've seen from Mr. Boyne's witness statement, once the experts are granted access to this material, actually there should be a high level of agreement in terms of what happened and what quantities were spilt and from where. But in any event, the numbers that we plead have always been set out as examples in relation to the quantity of oil, and I'll obviously come back to show you that. We also know that in the Bodo case...
Can I just just so that you know, it raises something which I find deeply troubling, which is you launch an enormous action requiring enormous resources, no doubt with the best of intentions, at a time when you are simply not in a position to come close to proving a case on causation. And then you come along and say, well, we've got to have disclosure, and I'm not on top of when you've made an application for disclosure. And I take the point about the years being lost to the jurisdiction. But it's a common problem with multi-party actions. It's always been a common problem, not just in environmental claims. That, if I can put it this way, in order to try to avoid the consequences of limitation, people put their head above the parapet too soon at a time when they can't. And having been on both sides of this particular Morton's Fork in the pot or whatever it is, it's very, very uncomfortable for a claimant who doesn't have the information to sustain a case and then gets skewered by defence, you would put it. I'm not for one moment accepting this as a proper discussion. Skewered by defence tactics who simply say you haven't got a case. But you can't use that as a universal answer.
No, but I'm not seeking to use it as a universal answer. I mean, again, we trespass into things that we will discuss tomorrow, but I'm keen that I address all points early on. The point is, and I will show you, we are being asked to plead something we cannot plead. We cannot plead until we have, and we've said this, and it's in statements of truth and it's in witness statements from those who instruct me. This is not a tactic, it's that we cannot.
I'm not suggesting it's a tactic, it's a difficulty, and it's all driven by limitation.
No, with respect, it's not driven by limitation, because even if we didn't have limitation, until we have access to all of the records and all of the material that the defendant has, and we give those to experts, and the experts use all of that material to produce what the defendants themselves will result in something that's agreed.
Okay.
It is simply not possible for a claimant to set out
I accept that. I accept that, and you're being very frank in accepting it too. But I don't accept it's not about limitation. If there wasn't a limitation act, either Nigerian or English, applying to your claims, we wouldn't be here.
Well, I don't accept that because the defendants won't give us the documents. So they again, we can go through the attempts we've made. I have 6 pages of requests that we've made to try and get disclosure. This is not a case where the defendant says, okay, fine, here you go, here's the disclosure, knock yourself out, go and see what you can do with this. This isn't us, this is illegal refining. There's been an absolute refusal to give us disclosure. We obviously then got to a point, and what's said against us is, until you plead something better, you can't have disclosure. This is fishing. Well, that is a catch-22. That will mean that these claims can't be brought. So it isn't just to do with limitation, because the starting point is that you must plead your case properly. We can't go in and be more specific until we have all that material. And the irony is, the defendants accept that when we have that material and the experts look at it together, they're likely to agree. And I address this point head on, that when you're talking about a claimant who has a contractual claim, it's very, very different, because that claimant knows that they are likely to have to bring a claim. They are in possession of information, they have the ability to record documents of what loss they've suffered, etc., and present that to the court. And that's why the court has no truck with a claimant who comes along and says, I can't particularise something. But in this case, we've suffered a variety of torts, a strict liability. I can take you through all the ways in which this claim is pleaded. The fact is, we are innocent persons sat there, we suffer pollution, and we then have to try and unravel that. And what is publicly available is not reliable. And we know that that is true by looking at the Bodo litigation. In Bodo, the volume was 100 times the JIB reports. So we're not talking about small inaccuracies. We're talking about a fundamental issue. We cannot, and we cannot engage the experts to do the job properly, as Mr. Boyne, the defendant's solicitor, accepts, until we have all of that material. Because otherwise you get into the old problem of garbage in, garbage out. You need all the material, you need two experts to sit down and to seek to agree many of these matters, and then the parties would actually be debating the issues that are important, that do matter, and that matter in terms of how you interpret these duties under statute, what the extent of the duty is. But we have spent 3 years going round in a circle about the specificity of these leaks and the causation issue.
Mr. A, can you at some point, not necessarily now if it would derail you, deal with the point Mr. Willan raised? He says that the 85 additional spills, or at any rate quite a lot of them,
Yes.
were publicly recorded on Shell website, the regulator's website and so on in 2012, and it can only
Yes.
be either by some inexplicable tactic or by negligence that you restricted yourselves to 10.
Yes, I can deal with that straight away. I'm keen that I deal with things that concern the court, rather than ritualistically going through submissions as long as by the end of it I've made the points. I think a couple of things. One, under 17.4, I think strictly speaking, this wouldn't be relevant because either we meet the test or we don't. Under 17.1 and the exercise of discretion, it may be relevant, but there is no appeal against the exercise of discretion if we are within 17.1. So the only appeal is you don't come within 17.4. If we come within 17.4, there's no discretion, so it's said, and therefore that's the end of it. But I can also, and it's important that I make clear to you, that the submissions that were made to you, again, are not accurate. If we can have a look at Modi 5, which should be in the supplementary bundle, page 552.
Do you know which volume?
Sorry, yes,
Two.
volume 2.
37.
And this, just so you can see what this is, this was a witness statement. It's page 537 that was filed on the 11th of July 2023. So this was actually the witness statement that was filed in relation to the proposed amendments. And you will see that there's a heading there of delay. And you will see that there's reference to the fact that the spills, so the same submission you heard this morning, had not been published on SPDC's website, do not fall within the definition of unpublished spills. And then unpublished spills, as defined in paragraph 13 of the reply, which again we can go to if we need to, those records published by HPDC do not include a substantial but unknown number of other spills and leakages which have occurred from the Bille pipelines and infrastructure, but which are not referred to in the records published. So the spills not published on SPDC's website are unpublished spills. Now, of course, the this morning there was an elision of SPDC's website and, sorry, I'm going to forget the acronym, it's another, Nostra, and Nostra's website. So just to be clear, unpublished bills must include those on Nostra's website. So we could only be talking about SPDC. And then secondly, you will see at paragraph 113, she cast doubt on the figures that Mr. Boyne has given and says the claimants haven't, Mr. Boyne says that the claimants haven't explained. And then she says at 114, I note from the information set out at paragraph 112, only 37 of the 85 were available on the SPDC website, and therefore 48 of the 85 were not available on that website in 2016. And then obviously at the bottom, the majority of the additional spills, 43 out of 85, have still not been published. And when one looks at the pleading, you will see that the distinction is drawn between the SPDC website and the unpublished spills. But
So where did you get them from, the 85? Or am I asking?
well, they come from SPDC and Nostra, which is the regulator. But you will see that none of this is terribly accurate. And
Is it disputed that the 85 were in the public domain when you pleaded your original pleading?
I don't know. I would have to
Well,
check
I
that.
think I would like to know.
Yeah. I think the answer is we don't know because we don't keep records. We didn't screenshot Nostra's website and what it showed in
Okay,
at
so
the time
there
of
is
the
no
pleading.
evidence to contradict the defendant's assertion that the 85 were all in the public domain.
Well, we don't. I think the defendant's assertion has to be treated with care because I'm not sure where their assertion would come from about the regulator's website.
By the end of this hearing, we need to have clarity one way or the other, I think. Because it's not good enough to go into a judgment writing not knowing whether something like that is common ground, disputed, evidence with contrary evidence or what.
But unpublished bills, and again, I am left slightly unsure what the defendant says about unpublished bills. But unpublished bills, at one point I thought Mr. Willan said they would allow unpublished bills, but at another point I'd understood that they're saying it's 10 or nothing more at all. But certainly the unpublished bills would encompass those that were on Nostra's website because those were not included within the definition.
Okay. I think I've made my point. And I accept what you say that you don't know the answer at the moment. It is asserted against you, as I understand it, and I'll be corrected if I'm wrong, that the 85 were all in the public domain and accessible when you pleaded your claim originally. Have I understood that correctly?
Yes, and we put in evidence that that's not right.
Okay.
My lord, I don't know, just so it's not been left that I haven't corrected that. In relation to the SPDC, what we can say is that 31 were on the website as of 2012, 37 were on the website as of 2016. In relation to Nostra, so that's the ones that are not published on the SPD website, but have now been found on the Nostra website, we have no way of knowing what was on the Nostra website at the time. But we have Mr. Boyne's evidence. These were all reported to Nostra. We know that because we've got the reports with the Nostra references. And he says there is no reason to suppose that Nostra didn't put them on their website as they were reported. But no one is able to put forward positive evidence as to what historically was on the Nostra's website. Obviously, what my learned friends haven't done is said, we looked at the Nostra website in 2015 when we pleaded this case and there were only 3 spills there.
Okay.
But that's as far as I
I'm
can
now
take it.
thoroughly confused, but I hope it'll. It's my fault, I'm sure.
But I think I was right. I think there is no evidence as to what was on Nostra's website at the time of the pleading. And that it is agreed that although it was originally asserted all of these 85 were known, in fact it's now accepted and this is in Ms Modi's statement, only 37 of the 85 were available on the SPD site. The second point that we make in relation to that, though, is the point that these are pleaded as examples, and I will come on to show you that. They're not pleaded as some definitive list. And secondly, it would be very dangerous to take them as a definitive list. This is a shifting picture, and I can show you from some of the footnotes in the schedule we pleaded how things shift in and out. This isn't an area where it is possible to be certain. Even the defendants haven't been certain, because they shift things in and out. They change quantities of oil in relation to the spills. My Lord Justice Bean, that it was addressed in that way. So when, in terms of what was submitted to you earlier, I'm afraid that wasn't accurate. There was a response. And as I say, nobody has put forward any evidence from Nostra. So if it's convenient to the court, I want to just continue making my preliminary remarks on both of the heads of the amendment. And as I say, I start with the illegal refining. And if we can go back, please, to the defence of the defendants. And I'm going to use the pleadings that relate to the community claim. Those were the pleadings that the judge references in her judgment. So I think this morning you had slightly different Dixie claim and defence. I'm going to use throughout the community claim pleadings. So this is in Core Bundle 2, tab 34, page 711. And if you look at paragraph 12, you will see that there's reference within that paragraph both to bunkering and to artisanal refineries. And then you will see at the end of that paragraph, the last three lines before letter A, notwithstanding the extensive steps taken by SPDC and the Nigerian military to combat the threat of third-party interference and illegal refining, the problem persists. So the important point is that in its defence, the defendants not only said that illegal refining was the cause of the damage, they also asserted positively that they'd taken steps to combat that threat. And we will see why they did that when we come to look at the Nigerian law provisions. But the outcome of that was then that there was an order made. This is the GLO order that's made in 2022. So if we go back to the supplementary bundle and we go to tab 22, page 443, this is on the 8th of June 2022, the order was made. And if we go forward to 459, you will see these. This is when Mr. Justice O'Farrell made the order for the GLO, and she directed that certain common issues be part of that. They're at Schedule 1. So this is the order of the court, never appealed.
I'm very sorry. But, which bundle are you in?
Sorry, supplementary bundle,
Yep.
tab 22. Page 459.
Thank you.
And these are actually issues that were proposed and then ordered by the court, but these were proposed by the defendants themselves. And if we go forward to page 460, if you look at 8, paragraph 8, it's been ordered that within this GLO, this issue will be tried To what extent, if any, and in what circumstances can a licence holder be liable under the OPA for damage caused by oil that is removed from a licence holder's oil pipeline or ancillary installation by third-party interference and subsequently used in illegal oil refining by third parties? So that's reference 1 to illegal oil refining. And then if you turn over to 15, issue 15, does Nigerian law impose liability on an oil operator under the Petroleum Act and or the Petroleum Drilling and Production Regulations 1969 for damages caused by oil that's removed from a licensee's infrastructure by third-party interference and subsequently used in illegal oil refining by third parties? So that is an issue that's been ordered already to be dealt with in the GLO. And then
all under the rubric that they're not a substitute for the pleadings.
no, they're not, but it does show what the defendants understood was at issue. So when we come to look at that, that's something that they have always understood was to form part of this trial. And then again, if we go back to Mr. Boyne's witness statement, we can see some further evidence of that. So 476 in his third witness statement, 9th of November 2022, page 478. So again, this is before any amendments are suggested. Paragraph 43. The claims seek to hold the defendants liable for environmental damage caused by sabotage, crude oil theft, and illegal refining. So that couldn't be clearer, that the defendant's solicitor in November 2022 saw that the claims, as one of those claims, was that we sought to hold the defendants liable for illegal refining. And then if you can also within this look at 61, which is at page 486. He repeats that. Relevance of third-party interference in illegal oil refining. As noted above, the claimants allege the defendants are liable for the pollution resulting from A, oil spills caused by third-party interference, and B, illegal refining. The defendants deny those allegations and insert that, and then SPDC can only be liable for oil pollution resulting from spills from assets were not caused by third-party interferences. Yeah. And then furthermore, as to B, the defendants assert that SPDC is not responsible for oil pollution caused by illegal refining. So at that stage, absolutely bang on point, saying that was to be part of the trial. No complaint, this wasn't pleaded. You will see that the footnote there is at 74. And indeed, the defendants were positively using it at this stage in relation to the directions that were to be given by the court. And we say in those circumstances to turn around and now say, well, this is a new claim and a new cause of action is not only unmeritorious, but also fundamentally wrong. It does, in our submission, fall within what Lord Justice Coulson said in Mullally and Martlet, which is in Authorities Bundle 4, tab 38. And you've been taken to certain parts of this, but I want to take you to some of the subsequent passages. And in particular, if we look at page 1606, paragraph 71, and you will see under the heading Appeal Ground 1 is the principal and Good and Martin limited only to facts pleaded in the defence. And you will see that that submission is firmly rejected. At 71 and 72, Lord Justice Coulson rejects the argument that the principal and Good and Martin only applied if the new claim relied on no new facts or matters at all beyond what is pleaded in the defence. Paragraph 73, he sets out that Good was not laying down any hard and fast rules about the precise degree of overlap. And then secondly, he says at paragraph 74, this ultra-restrictive approach is not what Good and Martin envisaged. On the contrary, Good envisages that the principle would apply to any facts which would flow naturally from the way the defendant sets up the evidential basis of his defence. Then if we go forward at 75, so over the page, if you look at, I don't think you need to read the whole of 75, but you will see that he says at the end, none of that arose out of the claimant's original pleading, but to prevent any criticism of the defendant's conduct of the jibe when he had himself raised it as part of his defence would have been unjust and contrary to the overriding objective. And then 76, he talks about how there can be no doubt that the amended claim in Good and Martin gave rise to an entirely new investigation involving new experts not previously required. That obviously is not this case, nor was it the case in Mullally. And then at paragraph 80, again, he warns against adopting an overly restrictive approach. And what he says, and I would invite you to read all of this section, in effect is the defendant can't complain if a claimant takes what the defendant has pleaded and turns it against the defendant and uses it against the defendant. So we say that on the basis of this authority, it is very clear that even if we needed to, even if we fell within 17.4, and our submission is that we don't, that you would be permitted to allow this amendment under 17.4.
What is the position if we were to conclude that the defendants understood from, for example, the terms of the GLO and Mr. Boyne's third statement, that a claim for the consequences of illegal refining was being made against them, but that on an analysis of the particulars of claim, they were wrong about that? What do we do then? What principle comes into play, if any?
Well, I say on the basis of Mullally that actually that isn't right, because...
Well, then you haven't answered the question. On that premise, what do we do?
Well, you'd have to unwind orders that have already been made. I suppose, strictly speaking, if the defendants had done something, the court has to look at, is it a new claim? Is it the same or substantially the same fact? There would be issues potentially of estoppel as to whether you could unwind it in that way. The reason I rely on it is to show that before this appeal, nobody ever thought of this argument for good reason, because it is obviously within the scope of these proceedings.
Why did you put forward the amendments?
Well, we put forward the amendments in order to clarify the position, and again, I can take you through the amendments. You can see that those make very clear what the allegations are to ensure that that they are set out clearly for trial.
But do you submit that properly analysed the issues which have been brought in as paragraphs 8 and 15, I think it is, of the GLO order, are raised by the pleadings as they now stand before amendment?
Well, of course, we wish our amendments to go in to be clear. What we do say is those facts are already in issue. That's the basis.
The
on
fact
which,
that illegal bunkering may be a cause of pollution.
Sorry. So bunkering is, I think, very clearly an issue. We can go through the pleadings. So third-party interference has always been part of our case. It's a moot point as to what third-party interference means. Yes. Of course, I've already shown you that the line isn't necessarily bright. So we do make the submission that third-party interference does include illegal refining. And you will see the way in which we've pleaded it, we've said including. But we obviously felt that it was prudent to set that out in detail, not least given the constant complaint that we're not being particular enough. So we have set that out. But even if I was wrong on that, we say that it's not a new cause of action because we've already pleaded third-party interference. And even if it was, it arises from the same or substantially the same facts which are already going to be dealt with at trial. And I do take issue with any submission that's made to you that you only look at the particular claim to determine that. Because Mullally says in terms, you can also look at the defence. Those are the passages that I've just...
Well, that's inevitable as a result of good.
Yes. But I think maybe I misunderstood it. I had understood earlier today a submission was made to you that the judge was wrong to look at the defence. With the greatest of respect, in my submission, she wasn't. Because one is looking at what is understood to be an issue in terms of the same or substantially the same facts.
The submission, as I understood it, was that she was wrong to look at the defence for the purpose of identifying the causes of action, but she was entitled to look at the defence for the purpose of whether the same facts were an issue.
Okay. Well, that's my... If that's agreed, then we can't be having this debate, because on any view, within the defence, as I understood the submission on the same or substantially the same facts, there seemed to be some point being taken that somehow, to be honest with you, I found it difficult to follow, because on the facts of the defence, it is clear that illegal refining is a central part. The defendant's responsibility for illegal refining is a central part of the defence. So those facts are in issue.
Well, Mr. Whelan's essential point, again, as I understood it, was that the critical new fact which would need to be investigated was the extent to which the oil which was illegally refined did not originate with Shell, but with other operators.
Yes, and that's, in my submission, that's wrong when you look at what's pleaded, because I've shown you where in the defence it was expressly pleaded out that they were not legally responsible for that. So there's never been any suggestion in the pleading of a third-party operator, so another operator whose oil has come in and added. The issues have been to do with third parties, so to do with bunkering or illegal refining. But perhaps what we should do is go through, because you haven't been taken through all of the pleadings, perhaps it would assist if I take you through the pleading, and I am going to do that by reference to the community claim. And to try and avoid us going through this twice, I'm going to try and address both of the amendments. Both of the categories of amendments. Before I do that, just a word as to where we've got to with amendment number 1, which are the additional spills. The way in which it was put in the permission to appeal was that our claim was restricted to 10 oil spills. And that's paragraph 27 of the skeleton seeking permission to appeal. The judge noted that prior to the proposed amendments, the respondents in the Bille proceedings only claimed in respect of 10 oil spills. Now, that is obviously not correct. The judge didn't find that, and that's not how we put our case. But there's a more important point, which is this. Today, it was said that the spill is the breach, and every time that you refer to a new spill, that's a new cause of action. We don't accept that. In my submission, the spill is not the breach, but the consequence that then leads to the damage. And what hasn't changed in relation to Bille are the breaches and then obviously the damage. So the damage is the damage suffered by the claimants. Every time there's an additional spill, that is not creating a new cause of action. It's just an example of a breach, a consequence of a breach.
Doesn't that at least depend to some extent on which kind of cause of action you're talking about? So if you're talking about strict liability for a leakage from a platform, from a pipeline under the OPA, then it would sound as if each spill is a separate cause of action. If you're talking about a generic failure to maintain a proper system of maintenance or something like that, then your submission has more force.
In my submission, it doesn't depend. I think it can be stronger in some cases than in others. But again, I will look at the OPA. Let's look at the OPA and how we've pleaded it. As Mr. Willen fairly accepted, some of these statutory duties are actually strict liability. And that's important because some of them, the burden is not on the claimants to prove anything beyond damage. So the liability arises when you have damage, and then the burden shifts, and this is all pleaded out, I will take you to it. The burden shifts to the defendant to show that they are not liable. Obviously, in relation...
You still have to show damage from the particular spill, wouldn't you?
Well, let's look at the pleading, because we don't necessarily accept that. That's going to be an issue for trial. Can we start by looking at the particulars of claim in the Bille community claim? And I'm sorry to do this, but this is one I've marked up because this is the one the judge refers to, and these are the amended particulars of claim that the defence that you've been taken to by both of us actually responds to. So otherwise you're looking at two slightly different sets of pleadings. So if we look, we see there that there set out is the summary of the claim, and it's said by Mr. Willen.
485.
485, apologies, yes. Tab 29, page 485. Now, Mr. Willen rather glossed over this, but you will see that this is part of our pleading. This sets out what our claim is about. And you will see that it obviously refers to serious and ongoing pollution and environmental damage caused by oil spills emanating from the defendants' oil pipelines and associated infrastructure, and then these words, in and around Bille Kingdom. So again, our claim has never been restricted to in Bille Kingdom. In and around has been there from the outset. And then we have, if you turn over to 487, we have the introduction to the parties. The community is obviously defined by reference to location at paragraph 6. And then 8 at page 488 actually defines, so the boundary of the community's communal land ownership set out in satellite maps annexed to the particulars of claim at Annex 1 and Annex 2. And one of the things that we will see probably tomorrow now is that the claimants have gone to Nigeria and set out GPS coordinates of where each of these claimants fished, and specific details have been given to the defendants in relation to the damage. Then, if we go forward, section C sets out the factual backgrounds to the claims, and we see at 15 the different types of damage that have been suffered. And this is important because there are different types of things that have happened. So obviously 15, we have the mangroves, aquaculture, creek, shrines and wells. Then at 20, and this is important, we have a description of the of what's happening in relation to Bille Kingdom. We have Bille straddles the area containing oil mining licenses 18 and 24. And then an explanation of where the leases cover, and you will see details are given there. Then at 22, we have reference to the defendants' oil pipelines and infrastructure in Bille, and then included the following. So again, examples of what that included. Obviously, the defendants know exactly what infrastructure we're talking about, and they know the complaint that is made. We can see that the definition of Bille pipelines and infrastructure includes 12 specific pieces of infrastructure: wells, manifolds, flow stations, and a trunk line. If we look at little c, the Nembe Creek trunk line, you will see when you look at the examples that are given of the spills, so this is the 10 spills, when we come on to those at page 10, page 494, that none of those spills actually comes from the trunk line, from NCTL. But it's always been clear, and there's never been any dispute, that the maintenance of all of this infrastructure is in issue in these proceedings. And then we see a longer description of the NCTL at paragraph 25 onwards. We have that was the main pipeline that runs through Bille. And then obviously what had to happen was there was a replacement project in relation to that. And you will see there pleaded out that it was part of the reason in the EIA for getting permission to do this was obviously that sections of that were easily accessible. Illegal bunkering activities occurred in these sections, and obviously the representation was made at E that Shell said it would be responsible for the protection of the environment that's likely to be affected. And then at 27 and 28, you will see that that was reconstructed and replaced between 2007 to 2011. So that sets the scene for then what we come on to at paragraph 29, which is the pleaded case, which is in 2011 to 2013, a series of spills from that infrastructure that's been described resulted in the discharge of significant volumes of crude oil into the creek. And that is the claim that is pleaded. And then obviously you have the consequences at paragraph 30. So that explains what has happened. And then you have the list of not just death of mangroves, devastation of aquatic life, contamination of wells, erosion of community land, desecration of shrines, abandonment of settlements. And then paragraph 31 says, in support of the above, the claimants will rely, amongst other things, on the following facts and matters. And these are then pleaded out as examples. They're not pleaded as being definitive.
Can I just pick up on that? Everybody in their first week in pupillage learns that a pleading has got to set out concisely the facts on which you rely. How do you square that with a device which is often used of saying inter alia and not putting in the facts on which you rely?
Well, because if you look at paragraph 32, we explain why we've done that.
Somehow, in order to avoid, on one view of the submissions, in order to avoid a finding that these are new causes of action, you've got to establish, or we've got to accept, that the current pleading covered and made a claim in respect of all spills.
No, because if you find, so I resist the appeal on two grounds. The first is that a new spill does not equal new cause of action. Because it's not new facts that make us fall into 17.4. It's obviously a new cause of action.
You say it's particulars of breach.
I actually don't even, I've thought about this a lot. I don't actually even think it's particulars of breach. It's been treated as particulars, and we'll see that everyone treated this as that they wanted further particulars. I actually think the correct legal analysis is this is the consequence of breach. So it's the link between the breach and the damage. It's the it's part of the causative root, it's the consequence. If you don't protect and maintain and do all the other things that we say they had an obligation to do in relation to their infrastructure, that in turn leads to a leak. And I can illustrate it, or a spill. I can illustrate it in this way. Imagine if you had an event, so someone, just for the sake of example, drove something into a pipeline that ended up causing one spill immediately, but then a second spill, say 3 weeks later, because it loosened something else that then only caused a second spill further down the pipeline sometime later. In my submission, that isn't a new cause of action. That's just the consequence of the original breach. So it's put extremely elegantly, and it sounds very persuasive. But in my submission, if you stand back and think what this means, it can't be right. In my submission, a spill does not equal a new cause of action. And if we also just stand back and think of the practical problems that would cause for any claim such as this, it would mean that every time we saw something that looked like an additional leak, spill is only used in the sense of leakage of oil coming out and going into the environment. Every time something like that happened, we'd have to issue a new claim form.
No. You work it through the other way around. You've got a claimant, or a potential claimant, who says, my land has been damaged by oil. The next question is, where does this oil come from? The next question is, who is responsible for that oil having come from there? If you look at it like that, at any rate, each new claimant is a new cause of action. Must be.
Yes, but we're not adding claimants. And you will see that one of the things these amendments don't do is we don't change the damage. So we've not added a single claimant because of these. We have not changed the damage. But we have given, in my submission, particulars of that link, of the consequences of the breach that flow through. It cannot be the case that every spill in this situation creates a new cause of action. Imagine if I was in the course of cross-examining somebody at trial and they admitted there'd been another spill and we'd had no reason before to think that that had occurred. What then would happen? Would I have to then try and amend to rely on that?
I've just written down that you challenge the view that every spill is or gives rise to a new cause of action because you say numerous spills may be caused by the same breach of duty.
Correct.
So if the duty is to maintain the pipeline, there's a failure to maintain the pipeline, never mind about third-party interference, it cracks up in 5 different places, then I can see your analysis that this is one cause of action. And if you find another crack a week later caused by the same mechanism, then I can see how you say that is all further particularization of the same cause of action. You've got the same duty, the same breach, which is the failure to maintain, and the consequence.
Yes, and
but that's how you put it.
it is, and I think it's very important that you don't equate spill and breach, because that's what happened during the course of the submissions this morning. And as I say, the practical consequence of that would mean if you didn't plead out every spill at the beginning, even the ones you didn't know about and couldn't know about, then if through, let's assume no fault of your own, you discover that there's been a spill, then that would create an additional cause of action. And this is the point when I think in the authorities, people say the level of, one has to be careful about the level of detail that one's going into, because we're now focusing on facts rather than causes of action. It still has to be a cause of action. We've pleaded the constituent parts of the cause of action. The second point is that we have actually pleaded it out in this way, and we say for good reason. The way in which the defendants challenged it initially, and we can go through this, was to say that they wanted particulars. Then when we give them particulars, the best that we can do, they then say, well, that's a new cause of action. That's what happened. They didn't apply when we served this pleading to strike it out. That's important, because they could have said you're restricted to 10 spills because anything else is not part of this cause of action. That's not what happened. I will take the court through that. But if we can just go forward.
Can you just help me with this? You said 10 or 15 minutes ago that there were 2 headline points you wanted to make, of which number 1 is a new spill is not a new cause of action. Just say, rather than leaving it for tomorrow, what's headline point 2?
Sorry, and headline point 2 is even if a spill equals cause of action, the way in which we pleaded this out was more general than just 10 spills.
Right.
We are right at the nub of a difficulty which afflicts almost every multi-party action, where claimants don't have the information for whatever reason. Maybe asymmetry of knowledge, it may be an inability or other failure to investigate. It may be anything. This is a problem which is not unique to this case.
Well, again, I would ask you to hold that judgment until you've seen what's actually happened in this case, because those instructing me, and I will take you to the statements of information, have been and talked to thousands of individuals and filed details of everything that they can actually remember and pinpoint. We have also gone to Nigeria and given GPS coordinates.
And we've got 2 of them, haven't we?
You've got 2 of them, but we can provide more. But tomorrow I will take you through them, because you will see the level of detail, everything that we could possibly set out on an individual basis we've done.
Okay, well, I mean, the first gentleman doesn't need an expert. He said, the first gentleman says, there's a manifold sitting right next to my land. Whenever I put my spade in, it comes up smelling of oil. So you can see how a court could make an inference from A to B without an expert. The next is the lady who lives near high tide. And that's the sort of case where you're going to need or would need additional support from expert evidence.
Yes, but that's evidence.
Yes,
That's evidence. The court, in my submission, this may be the problem with these types of cases, is that they need clear direction from a court such as this. That actually the way forward is not to get embroiled in these pleading disputes, just as we've had expert evidence have a very positive impact on proceedings generally. Here, the defendants themselves, and I appreciate this will be different in every factual situation, but when we go on to see what the defendants are responsible for, they're responsible for these pipelines. They're under strict obligations to keep really good records of maintenance. Any leak, they have to investigate it. In fact, we say they haven't complied with that. But they still are confident that once all of the information that they have is disclosed, once the experts work together, the experts will be able to tell the court what happened.
I must say that looked like wishful thinking to me, but there you go.
But that is important, because, my lord, that comes from the defendant. That comes from those who know, and that is actually our understanding of having talked to our own experts. And you will see that Mr. Leader has talked to his own experts and set out equally what they need. There's actually a large measure of agreement in terms of what these experts think they can do. And one often might see that fire experts, for example, reconstructing the cause of a fire, often can reach agreement on these things. But certainly the defendants are confident that that's what can happen. It has, though, in my submission, to be preferable to this situation of taking 3 years where we are still arguing about pleadings and where we cannot do anything more. We again, I will show you tomorrow the extent to which we've gone, but these are not claimants issuing at the end of limitation and trying to not comply with their pleading obligations. We do say that we have pleaded this out in detail and included absolutely everything that we can at this stage. But now we need to get to the point of having the individual lead claims and then the disclosure.
Right. Is that as it were, the end of a paragraph?
Yes, I'm conscious it's been a long day.
No.
Hopefully I can then make my submissions. And apologies, I'm dodging a bit between the 2 appeals, but I hope it's helpful for you to have that.
That's fine. Right. Unless either of my colleagues has any questions to ask, we'll resume at 10:30 tomorrow.
What lies available?